So once again, my name is Emo Kinievo-Dafe-Akwede. I am the managing partner of Campus Mentis Legal Practitioners, and I'm also a board member at Restorative Justice for Africa Initiative. So this morning, I've been asked to speak on just to enlighten people about what restorative justice is about, and it will give a brief insight as to what we do at Regia Initiative. So I guess the first question is, why restorative justice? Why should anyone in the criminal justice system recommend or use restorative justice? And before we delve into that, it's very important to distinguish what we have in our current criminal justice system, which is more retributive justice, and distinguish that from restorative justice. So under our general and criminal justice system, we have what is retributive justice, which is solely based on the punishment of the offender. The victim, or what we call the complainant, and the offender really have no input into the system, apart from when the victim has to give evidence in court, which we know as, and many people know as lawyers or people that have watched victims have to give evidence in court. It can be very scary and frightening for most victims. For the offender, it's either just about escaping the harsh reality of imprisonment, or if he has confessed, then he or she is sentenced for the crime. And there isn't a lot of focus on reforming the offender. Although it's now known, instead of prisons, it's now known as the correctional facility, to change the nomenclature so that offenders are actually corrected in the system. We know in practice, it's just really about punishment. There isn't any corrective measures being taken for most of the prisoners. So that's our current system. Now, this is totally different from what we have under restorative justice. Now, the approach in restorative justice is about the victims, the offenders, and possibly the wider community being involved in the process. And I will explain that further. So this could involve possibly maybe writing of letters. It could involve setting up what we call a conference meeting between the victim and the perpetrator. In some communities, it might even involve the local heads of the communities to represent the larger communities in those meetings. I think someone's mic is on. Okay, I'll continue. So the point with restorative justice is that it involves everyone. It's a holistic. From the victim's point of view, the victim gets to be heard. In our criminal justice system, many times the victims are not really heard. When you come and lay your complaint, the police, the DPO, and the state decide whether or not to take up your case or not. And you're only involved, as I said, for the purposes of coming to give evidence. But the hurt you feel, the time, because it's very time consuming to go through a criminal justice process in the court, none of that is being taken into account in our current system. And that's what restorative justice seeks to fulfill. So sometimes it's as little as an apology. And I'll give an example. There's a current case when we went to visit the prisons, the correctional facilities, the medium correctional facilities at Nasarawa last year. The young man, only 18 years old, had been arrested because he stole one chicken from his boss. Now, when we interviewed him, we asked him, okay, let us have your case. And he said his boss had been owing him 2 months worth of salary, and he was hungry. He had no money to fend for himself. So he took the value of the chicken, basically the value of what he was being owed in the form of the chicken, so he could either sell it and get some money. Now, the boss obviously was very upset, and he had reported him to the police, and now he was locked up in a medium correctional facility because of one chicken. Now, this is a classic example of something that could have been resolved in a restorative justice approach. And that's why, and I will explain that later on when I say the steps on how restorative justice can be employed. But that's just one example of low-level cases like that really don't need to be in our criminal justice system. And that's the reason why restorative justice has come in to fill that gap. So what I want us to get in our minds is that restorative justice is a different approach. It's a victim offender approach as opposed to the state approach, because restorative justice is based on restitution with input from the victim and the offender, and possibly their wider community. Whereas what we currently have, which is retributive justice, is based on the punishment of the offender. So that's just a brief highlight as to why restorative justice is important to be implemented in our criminal justice system. Okay, and then I'll give several other reasons. It allows the victims to feel involved and heard. The clinical approach we have found is very victim unfriendly. Many times you find out that victims are very reluctant to give evidence in court. It's a very clinical, very sterile system, and counsel is asking you cross-examination questions to trip you up. And sometimes victims end up feeling victimized again, all over again by the criminal justice system. And this is why we have, it's important to bring in restorative justice. Also, in countries where they have adopted restorative justice, mostly in the United Kingdom, in New Zealand, in Australia, they found out that victims have had high level of satisfaction with that process. Many are able to reclaim what has been taken back from them, and they feel a better sense of security and tranquility. Again, I'll give an example. There was a case, one of the studies we did, there was a case that the lady's bag had been snatched. Okay, so she was walking down the street and her bag had been snatched by someone who was actually, the people in the community knew the guy. He was a bit of a petty thief, if we can call him that. And so the case was referred to restorative justice. And in the process, the lady was able to say how she really felt, the insecurity she now felt walking down the street because of what the offender had done. The offender had been able to explain, okay, he actually stole this, he didn't really want the bag, he just wanted some money to eat or something like that. And he had understood the harm that was, done to the victim. And there was a meeting of minds, as you would say. The bag was returned, the lady felt some sort of security, and the offender was put into some sort of program to assist him so that he could actually get a job. So these are some of the ways restorative justice have come to play in other crimes, and which is why we say it has high victim satisfaction. Now, also, it allows the victim to, instead of being re-victimized, as I said, under the criminal justice system, it gives them an opportunity to kind of put the incident behind them in a more productive and healthy way. We found out that most times with restorative justice, it can be a bit therapeutic. People are able to, with the facilitator, able to express how they feel, as opposed to answering questions for the purposes of prosecution of the offender. So again, this is why victims have preferred restorative justice, because it is a process that allows you to air how you feel instead of just, oh, these are the questions I'm going to ask you if I'm the counsel for the prosecution, and then being tripped off by the counsel for the defense. So it's a much more relaxed, supposed to be a much more relaxed atmosphere for victims to really say their minds. And also, as I said earlier, it can be crucial for the community to stop offenders from returning to crime, because when you have a process that gives you a way out of your current situation of crime, programs that you can be put into either through NGOs like ourselves, we do in Regia, or other government programs, then you have a way to stop reoffending. And this is why restorative justice is very important. Again, if you know anything about Nigerian justice system, it's mostly justice delayed because of the inundated adjournments. You're looking for files, the IPO is not available. You can have a case running into years. Now, if that simple case had been referred to restorative justice, that matter could have been sorted out in a matter of weeks, which again, we all know justice delayed is justice denied. If as a victim, I can feel heard, I can get justice in a matter of weeks instead of years, then I'm happy with the criminal justice system. Then I know that I am actually being heard and my voice really matters within the system, okay? So again, this is just an overview, and this is some of the brief reasons why restorative justice should be employed in our criminal justice system. Now, the second part of what I've been asked to speak on is how do we deploy restorative justice within our system? Now, this depends on the crime in question. I remember when we did a training recently for some of the police officers in Nasarawa, one of the complaints they had was oh, do we refer all cases to RJ? And I said, no, not every case might be appropriate for restorative justice. And it may also depend the stage at which a case is on. So I'll give an example. First of all, before I give the example, let me just say that restorative justice can be used at any point of the process. So it can be used pre-trial, just when you report the matter to police. It can actually be conducted after trial and even after sentencing of the offender. So there are many stages at which restorative justice can be used. So let's take the example of low-level crimes, public nuisance. Somebody defaces a property, graffiti on a property, which we normally say is criminal damage to property, and that's a criminal offense. Now, instead of locking the person away, the person can't make bail, or prosecuting that person, and the person is either made to, go to prison for that kind of low-level crime. At the point of making the complaint at the police station, the police can actually refer the case to restorative justice. What we have found, and Lagos has tried to do this, although it hasn't been fully implemented, is to create restorative justice centers, where you have restorative justice facilitators to engage with the victims and the offenders to resolve their issues. So again, as I said, this can be done at that level, even before we start talking about taking the case to court or to trial. At the point when it is reported to the police can say, okay, you stole a piece of, let's go to the chicken example again. You stole one chicken because your boss didn't pay you. Is this something both parties are happy to discuss with the facilitator to reach a resolution? And the victim may say, yes, the chicken costs 8,000 or 10,000 naira. It's going to take me 10 years or whatever before I see the end of this matter. If there's another option, yes, I'm willing to go through this process. And you find out that maybe in that scenario, after they've had that discussion, the facilitators have come in, spoken separately to the victim, the offender, and have then they now engage in a three-way conversation in a meeting. You may find out that the boss may say, okay, fine, we're going to deduct that as value earned since we have not paid your salary. Or we say, okay, here's this, I'll pay your salary, but then you have to pay me the value of the chicken or whatever it is. So there's a myriad of solutions can come out from that problem depending on the meeting and the discussions between the victim and the offender. Of course, with the facilitator there as a neutral to mediate between the two parties, okay? So that's one way already. At the point of reporting to the police can ask that a party is happy to refer this to restorative justice. If they agree, it can then be referred to the restorative justice centers, and then that process can get underway. Now, this leads me to my second way that it can be deployed. It can be deployed through the judiciary. So sometimes maybe the police are not aware that this restorative justice system exists, and then they refer the matter up the ladder. A report has been given that the person should be prosecuted, and then it goes to court. And then the matter comes up before the honorable judge, and he or she believes that, no, this matter is such a simple matter. Like, okay, yes, you took a TV. Where's the TV now? Actually, the TV has been returned back to the victim. Okay, so does the victim want to continue this case? Are they willing to resolve this matter within the restorative justice ambit? And they say yes. The judge can refer that matter to RJ, which is what we call restorative justice. In fact, under the new Nigerian Correctional Services Act of 2019, that act speaks directly to the correctional services liaising with the court on restorative justice mechanism. So even in our laws as it stands, they recognize that there is an avenue for restorative justice. The only problem we have is that it's not currently being utilized. So specifically, if you look at Section 43 of that 2019 Act, it provides the platform for restorative justice measures. And it states that the Comptroller General of Prisons is supposed to provide these platforms. And there are a myriad of ways that that's done. It could be victim-offender mediation, as I spoke about. It could be family group conferencing, because sometimes you find out that the crime is done by one family member to another family member. So then that's not just a regular victim offender. It's actually a family issue. So sometimes you can have that. It could be community mediation. That's also possible. There was again one of our seminars. One of the stories that we're told about was in a particular community. There was an issue between the Okada people there the police. So the Okada people were constantly being harassed by the police. Some of them would be arrested unlawfully or whatever it was, and they felt, they were feeling victimized. And this sort of process was adopted. The police were invited in, members of the community were invited in, including the Okada Riders Association, and they were facilitators in that meeting to resolve that problem as to, okay, this is why the police are harassing you, because they feel that, okay, Okada drivers at particular points in time in the night could be a problem in terms of crime and all that thing. And then there was a resolution. Okay, these may be the hours of operation or whatever it was that was resolved at that meeting. The point of the matter is that RJ, Restorative Justice, was able to resolve that issue amicably without, riots between police and the Okada people. So there are many ways it could come in, as I said. So again, going back to the Correctional Services Act, it's provided for. There are many ways within which you can do restorative justice, even in the correctional facilities. So in this scenario where the judge actually refers the matter to restorative justice, if the correctional facilities has already set up an RJ center, then that matter can be dealt with there. Of course, we know this is Nigeria. Many correctional facilities are not even equipped to deal with these issues. That's why they come to other organizations such as REGA to assist them in this area. Okay, we don't have this system in place. How can your organization help to resolve some of these disputes without continuing in the criminal justice system? So again, that's another way. Similarly, for cases you cannot use restorative justice during the pendency of the matter. An example may be a domestic violence case. Of course, in that case, the victim is very fragile. You may not want to, get the victim in contact with the offender at that early stage. But even after the offender has served their sentence and they see, they get to see that actually I've harmed somebody and I would like to make amends, restorative justice can still come in. You can still have a victim offender conferencing, even with members of family, which will now be sort of a family group conferencing, to resolve some of the pent-up tension, which may have affected people for years and years before that. Of course, as I said, when it comes to things like that, domestic violence, it's a very delicate approach, and you need to have very trained facilitators to assist in that process. But it can actually come in even after sentencing and after a person has served their sentence and it has been released, and he or she has been released. Again, another way when we're talking about after sentencing and after you've been released, there are several programs that, for instance, REGA Initiative does to assist offenders. One of the problems we have is that after somebody has been punished, there is no re-entry into society. There is no rehabilitation part of the criminal justice system. Restorative justice can still come in. After you have that meeting, yes, the offender victim, they have discussed, the victim has let out how they feel. The offender has also felt, oh, this is the harm I've caused, and has also expressed how he or she feels. There must be a way to reintegrate that person into society. That's how RJ comes in, or RJ facilitators or organizations like ourselves come in to assist them in terms of programs they can do to reintegrate into society, whether it's learning a trade, whether it's being involved in some sort of government programs and all that. RJ institutions assist also in that regard. Okay. Now, the final thing I want to note in this whole issue of RJ is that our current Administration of Criminal Justice Act of 2015 was supposed to adopt a more restorative justice approach. A lot has been said of that act when it was passed that, enough of this, retributive justice, it wasn't actually giving us satisfaction with the criminal justice system. And if you look at the act, you will see things like plea bargaining, which was never included in our jurisprudence before that act. Now, if you look again specifically at section 314 of the act, it provides for what we call compensation to victims. So what used to happen prior to the ACJ of 2015 was that if you as a victim, as I said, came, you gave your evidence in court, the person was sentenced to whatever it was in prison, but you have actually lost something, say the person stole your TV or something like that, and we cannot even find the TV, you've actually lost something. There was no sort of compensation for the victim. Remember I said that the criminal justice system was not really victim-based. It was basically on punishment of the offender. Now, under the Act, it says, no, the judge could award commensurate compensation to deserving victims of crime. Okay, that seems to be a more victim-led approach. What the challenge with that compensation was is that it never took into account the offender. And it actually never also really asked the victims what they wanted in that scenario. Again, I take it back to our visit to Nasarawa. Some offenders, they had been prosecuted, they had been sentenced, and the sentence was a fine, a monetary fine. Many of them, because of hardship of life, they couldn't pay the fine. So we decided to take up some of their cases and pay their fines as little as 10 to 25,000 naira. Only for us to realize that they had compensations in the millions of naira. So your fine is about maybe 15,000 naira, and your compensation is 800K to 1 million naira. So invariably, that means you can't be released from prison because you have no means of ever paying that sum of money. Now, that's not a very restorative justice approach because it has not taken into account the offender and not really taking into account the victim, because the victim is never going to see that 800,000 naira. The victim may have even moved on and is not even interested in the 800,000 naira. The person may have been so disillusioned by the criminal justice system and the pain of going to court, week in, week out before judgment was reached, maybe 2-5 years later. So again, yes, the Act was trying to provide a sort of soft landing for victims, but it has actually created a worse system where you have people in prison who cannot pay such exorbitant fines. So my point on this is that we need to refocus our minds on how we use restorative justice and our restorative justice approach so that we involve all parties, the victim, the offender, the community in our criminal justice system. That's all I have, and thank you very much.
Thank you, Emokinova. That's a wonderful one. Can we give Emokinova a hand of applause? Thank you. Somebody's already giving a hand of applause. That's a very wonderful one. Thank you, Emokinova. We really appreciate for that seminar and presentation. If we are still here, can we kindly introduce ourselves to show that we are here? Just say hi, I am this on the chat box. Just hi, my name is Chibweze, something of that nature, hi. So we could just know each other a little. So just put up a hi, my name is this on the chat box. If you are still with us, that's nice. And Bless is putting up hi. So that's a wonderful one. I'm sure some of us have questions. So just note your questions so that we'll take everything together. So currently we have supposed to be our first speaker, but now our second speaker, Mr. Gift Ibukwe, on the call. So while on his way to the webinar, he had a bit of issues. So, so a little bit of what Emokinova said. So Emokinova was able to speak to us on why restorative justice, why RJ. So we call restorative justice RJ. She explained to us a point where it helps prevent re-victimization, right? It helps bring the closure to the victims as against going over the issue over and over again. If most of us that are lawyers, if you've ever been to the police station and how they tell you come today, come tomorrow, and the same issue are being repeated over and over again. And she mentioned that RJ can be therapeutic, and also it can stop offenders from returning back to the crime, especially when there is a provision for a reintegration and rehabilitation in the system, which our current retributive system does not take cognizance of. And also it can also reduce the length of time that cases are before the dockets of the court. We've had some cases where some of our volunteers had gone to, and then we've had to sign, if you follow us on our social media handles, you see some of the updates where we had to sign this RJ agreement where the offender had confessed and apologized for the wrong done, signed an agreement on how to return most of the times the money taken and whatever the case might be. And what we do is to now follow up to ensure that those agreements are met up. So in this way, people don't get to go to the courts over and over again. And sometimes you go, the courts are not sitting, or sometimes the judges might decide not to take the case or whatever the case might be. So ROJ might not be perfect, but ROJ had come in to bridge some of these issues and to heal some of these wounds in the society. So also Emokinova now took a step further, and she also spoke to us on some of the stages that ROJ can be implemented. And she mentioned it can be at the pre-trial stage, the trial stage, and even after trial. That's 3 stages. And she also told us how it can be done. So you have the victim offender mediation, the family conferencing, and also the one that involves the community. So please keep your questions there. We want to quickly welcome Mr. Gift Ibukwe, and as we mentioned earlier, he's the team lead of social development unit at Prawa. He's a titan in this access to justice business. So not much ado, welcome Mr. Gift to speak to us for the next 23 minutes on the origin and the history of restorative justice in contemporary Nigeria. Thank you very much. The floor is yours, Mr. Gates.
Okay, thank you very much. Good morning, everybody. Thank you for having me. It's good to be part of this program today. I hope you can all see my screen. Can you? I want to believe. Hello?
Yes, we can. Yes, we can. Yes, we can.
Okay, perfect. All right. Okay, so it's very good that we're treating this because just like I heard the first speaker point out some of the key issues that we are battling with in the Nigerian criminal justice system, especially the issue of the slow pace of dispensation of justice, how it has led to injustice itself. Because just like we normally say, and people will say that justice delayed is justice denied. If you're incarcerating a man for minor offense or petty offense, and at the end of 2 or 3 years, you say he has no case to answer, therefore he should go and sin no more. But then you didn't take into cognizance the time he has spent, the suffering, the mental and psychological torture he has gone through. I don't think that is justice on his own. Or at the end of the day, you say, oh, we're compensating you with 500,000. Even if you give him ₦1 million, it does not equate to the time and the torture that such persons have been subjected to, given the fact that his offense is a petty, minor offense, which in the first place shouldn't even be brought before the court of law and all that. All right? Okay, so this morning I've been given just 2 simple tasks, and I'm going to run with it with the speed of light. Discuss the origin of restorative justice in contemporary Nigeria, then look at restorative justice featuring in the Nigerian legislation. And that is simply looking at the framework of what supports or what backs the restorative justice within the criminal justice sector. So quickly, I won't want to go back to what the first presenter said. Just like he rightly said, one thing we should know is that restorative justice is an alternative approach to the traditional retributive and punitive justice system that we already have in Nigeria. And restorative justice aims to repair the harm that have been caused. So if it's not repairing that harm, bringing closure to the victim, bringing the primary offender and the secondary offender together to resolve the issue and find a sustainable moving approach, then that is not restorative justice. It could be something else, but that's not what restorative justice. So have it at the back of your mind that it is an alternative sentence, what you will call the non-conventional sentencing method or incarceration method, what we call the non-custodial, part of the non-custodial measures we have at the global stage, regional and national in Nigeria today. So in Nigeria, restorative justice is gaining popularity. And this is simply because of some of the key issues that the stakeholders and practitioners are beginning to notice. So if you have, as I speak to you today, over 72% of the people in Nigerian correctional service centers alone, I'm not talking about those in police detention, I'm not talking of those in NDLA, NAPTIP and Co. Nigerian correctional service, over 72% are awaiting trial. In that awaiting trial, you have majority of them people who are dealing with petty offenses, minor offenses. And in so doing, you have not in any way addressed the issue of justice. And what you're building is people who are beginning to build a behavioral pattern in the school or university of violence. So they go in as first-time offenders, they come out and they become recidivists. So that's what you get. So because of that, and so much effect that it is having in the society, people are beginning to make urgent call in that regard that we should adopt the concept of restorative justice. Holistically, restorative justice program in Nigeria currently employs a multi-agency, multi-sectoral, multi-dimensional approach. Yes, some of my colleagues here might argue that some of the things that people term restorative justice might not be. But remember, if we want to compare ourselves with what we have at the global stage, at the international stage, and regional stage, you might say Nigeria is a toddler in this regard. So what we're doing is a lot of try and error. We'll not get it right now, but the truth is that we're employing a lot of things. Anything that will help speed up criminal justice processes in Nigeria would do. So you might see what a lot of people are doing. They call it restorative justice. But if you look theoretically at the empirical stage, it might not really be exactly. So, but holistically, we are employing a lot of approach to see what best suits our community to serve that purpose. Also, it is equally important to know that because we are people who have practiced retributive justice and punitive justice system for a long time, you see there is a lot of resistance from stakeholders in trying to implement restorative justice. They prefer the old order, and which is common to man's nature, something you are very used to. Now, trying to just make a paradigm shift to begin something new, some of us, even at our adult age, you might struggle to deal with that. So the same thing with the institutions, because this is what they've known for ages. So take, for instance, before 2020, Nigerian Correctional Service Act is older than Nigeria as a state, Nigeria as a country, 73 or 74 years plus. So imagine if you have a legislative piece older than the country, and all of a sudden you want that institution to be practicing what you call best practices, you're going to have a whole lot of issues. So those are some of the key issues in the overview. So quickly, the origin of restorative justice in contemporary Nigeria. Restorative justice in itself is not new to the Nigerian community, Nigerian society. The only difference is that just of recent, some couple of years back, decades back, that we began to legalize it. There is a legal framework to that concept. So this has always been in Nigeria for more than decades, over 10 decades. You know, in our local communities, for some of us who are from the South, and Southeast, there are communities that still practice it today. When they have issues, they say, don't involve the police, don't involve state actors. You call your kingsmen, then they settle it. It has always been there. The only challenge is, given the popular narrative that Africa does not have proper documentation process, so we cannot say, oh, at this stage, in the year, in what century did we start practicing it? But it has always been there. The only difference is that there was no legal framework to that effect, but communities in their small assemblies have always practiced this. So, but it's equally important to understand that if you look at what the communities have been doing and what the legal framework talks about currently, you see that there is a lot of similarities and points of interchange, all right? So, and because this is based on the principle of restitution, compensation, and reconciliation, you see that it helps resolve conflict within the community. And that Nigeria has always practiced. But during the emergence, or when we entered the Fourth Republic in 1999, with the emergence of the Nigerian Constitution, 1999 Constitution, we saw a lot of civil unrest here and there. And the practical example is the formation of the Niger Delta Dialogue and Contact Group, which some of us must have heard or read about. And this was created formally in 2004 by the then president of Nigeria. And this was to address the agitation in the Niger Delta. And if you see the approach they used, remember what I said earlier, in Nigeria, we're using a multi-dimensional, multi-agency, multi-approach to implement restorative justice. So what they did there was to see the conflicts and the back and forth between the youth and the youth of the Niger Delta community and the oil producing firms. The federal government have to come in and say, let's do this, let's have a dialogue. And it's, okay, we are the victim, the community, the Niger Delta communities claiming the victim and say, oh, these people have been ripping off stuff, you know, making mess of our community. And, you know, that process that you bring the victim and offender, everybody air your opinion and say, what can we do going forward? Is there compensation to be paid? do you need to do, and that was what this NDDCG group did in 2014 to resolve some of the crises that was getting out of hand. All right. So looking at the legal framework, which is the second part of this, we see that from 1999, the Constitution of the Federal Republic of Nigeria, chapter 4, section 34, section 35, talks about, the fundamental rights of a Nigerian, right to this, right to this, right to that, right to, all those are embedded there, but was not explicitly, there was no place where it explicitly talks about restorative justice. But then when you look at restorative justice, you're talking about issues that have to do with the rights of individual, whether victim or offender. One thing people must understand when you're talking about the criminal justice processes and acts that goes, the fact that somebody is an alleged suspect, even if he's a convicted individual, he still have a right. That's what people do not understand. Sometimes you tell people that, do you know that terrorists have a right? It sounds very absurd. Oh, I'm sorry, but that is what the law says. So the 1999 Constitution talks in clear terms what the right of every Nigerian is, all right? Of course, when people come in conflict with the law, some certain provisions of that right might be withheld as a result of their action and inactions. In 2007, the National Judicial Policy document came out, and here they began to look at how can this issue of restorative justice, and this is because if you look at the data coming from the Nigerian prison then, now Nigerian Correctional Service, you see that there was a lot of overcrowding, abuse of people's rights. Remember, we're just coming out from the military rule. So the issue of fundamental human rights is strange to the military. They are not wired that way. The National Judicial Policy meeting that produced the policy document talked about what are the alternatives. I know most of us here, maybe it's in the pictures you must have seen. Formerly, when you go to the Nigerian prisons of those days, inmates are in chains. I don't know how many of us who have been to prison or witnessed it. I think when I started, I saw some of it, but that was like at the phasing, they were already phasing out. But if you look at the catalog that some organizations such as Power and maybe the CLOs and co had from the prison those days, once you are in the prison, you have that issue of you'll be chained, especially when you are not condemned, that's the case. Your case is worse, they can barely walk. They are like the chains in their hand, in their leg, sometimes to their neck and all, looking like the slave trade thing because they were inmates. So some of the things that this National Judicial Policy documents address were there, and talking about how can we even take off people who are minor offenders and maybe treat issue of restorative justice. Then we moved to 2011, where Lagos State proactively began to work on the Administration of Criminal Justice Act of Lagos State. Though the discussion started the same time as this 2007, but 2011, they have a document that, everybody was like, wow, this is fantastic. Then we moved to 2015, the national, looking at the template, the roadmap that the Lagos State government did and began to adopt something at the national level. And by 2015, you have an output, all right? Now, there you mentioned that. So you see, from that point where the conversation were looking at 2011, you see that the color is blue. Why I use that is because at that point, you're still talking about state. So the jurisdiction, very restricted, only Lagos State. Now, but about 2015, you begin to look at, there are a lot of things that were said about, alternative sentencing, non-custodial measures, community service, it began to gain a level of national prominence, all right? But by 2019, the Nigerian Correctional Service are explicitly mentioned restorative justice, talking about when and how to apply it, all right? So going forward, what that gives us is that if we're going to use data based on where we're coming from, that means in future, we're looking at bigger mechanisms that can talk about maybe institutions, commissions, and bodies that might be saddled said before.
Hello, everyone. I think Mr. Gift might have had a break in transmission. Mr. Gift,
Hi, can you hear me now? Can you hear me?
Welcome back. We can hear you now, sir.
Okay. All right. Okay, so I guess that's the network glitch. All right. Okay, so as I was saying, because it talks about retributive system, is always the offender versus the state, and not putting into cognizance the feeling and the input from the victim. You see, we begin to move. So that's where the Constitution is always talking about protecting the right of the citizens, the right of the city. But sometimes it's equally important to hear what the victim think about that particular situation or that context. And I don't think I need to go back to explaining that, because the first speaker did justice in that regard. And these are some of the documents, chronologically looking at it: the Constitution 1999, the National Policy Document 2007, the Administration of Criminal Justice Act from 2007 to 2011 at the state level, but at the federal level you have in 2015. Then you have the, excuse me, okay, so you have the Lagos State Restorative Justice, which is equally helping. The truth is that why I included this here is that it's equally made a lot of contribution to the emergence of the Nigerian Correctional Service Act of 2019, and which holistically talks about all these issues regarding that. Yes, there's another piece of instrument I didn't add here, that is Nigerian Police Act of 2020. There is no place in that instrument where it expressly talked about restorative justice, but there are sections that provides and supports for effective implementation of restorative justice in Nigeria. So in conclusion, we can see that the emergence of restorative justice in Nigeria help present a shift from the more towards a more victim-centered and community-based approach to justice. I know the first speaker mentioned that, and it's equally important that I reiterate that here, that beyond providing closure to the victim, is equally important that the community understands how the judicial processes work. So I'm going to give you a very classical example. If somebody breaks traffic rule, which you can consider as a very minor offense, not a serious one, and he is seen as somebody you can call the HNI, high net worth individual in the community. Now, he does that and nothing happens. The members of the community would further say, oh, this is a lawless community, we can do as we want. But imagine using a community-based approach such that, oh, this thing you did could harm somebody, could lead to the death of somebody. And because of this you did, you will do community service, you will do this, you will do that. And when people see it, it becomes like, it serves as a deterrent and say, oh, not the way the retributive system will present it, but you're like, oh, if somebody like this can pay or compensate for this act, that means it is not good, and raises awareness. It raises awareness. It makes the victim to be more accountable, all right, in that process. So what that does is that it brings the community into the equation. Unlike before, you say the state. Who is the state? The state is actually the state actors itself, which a vast majority of the community are not a member of, all right? And moving further, legal backing, the framework we have now, further deepens the usage of restorative justice and increases knowledge in this regard. See organizations such as REGA, giving a legal backing to restorative justice in Nigeria, where one or two legal instruments are citing in that regard. You see, it increases the knowledge in that area. I know REGA will be working on a lot of documents, policy brief, policy analysis as regarding that. That is because there is a legal backing, and you can walk into the courts to even begin to drive processes or mechanisms that would further promotes more, all right? Also, it aids proper and effective implementation of restorative justice in line with international regional instruments, which Nigeria is signatory to. So we have a lot of international and regional instrument that Nigeria is signatory to? Are we implementing? So when you call for some of the reports in 3, 4, 5 years, some of them as good as 10 years, Nigeria has not done anything in that regard because we do not have legal backing at the domestic level that can help do that. And lastly, it promotes speedy criminal justice processes in Nigeria. So on this note, I would like to say thank you for listening, and I hope I am within time. Thank you.
Thank you. Thank you very much, Mr. Gift. You are well within time. That was a wonderful presentation. So once again, can we give Mr. Gift a clap, a hand of applause? Let's appreciate Mr. Gift for this wonderful presentation. So Mr. Gift has done quite a lot. He introduced a concept in his presentation, the non-custodial measure. So restorative justice is actually one of the non-custodial measures in criminal justice administration. Of course, he made reference to other forms of non-custodial measures. Then he gave us a very scary statistics that 72% of the inmates in the correctional centers actually are awaiting trial, and most of them are for petty offenses. Our first speaker, Mokinovo, mentioned that, like the guy that took a chicken and some other cases that we've encountered, petty offenses, but we've seen most of them have spent 1 year, 2 years over there. Some of them, you go to the courts to check their file. The files are empty, which means that they are dropped in the correctional centers and nobody follows up on their case. He also talked about, he mentioned something I think is very interesting, behavioral patterns in the school of violence. Yeah, Mr. Gift mentioned something like that, behavioral patterns in the school of violence. He now mentioned that sometimes people go in as first-time offenders and then they are coming back as recidivists, okay? Because when you get into the correctional centers, you realize that you are very hardened. So on the history of restorative justice, he's told us that at the moment, Nigeria is employing a multi-agency approach that involves the police, the community, and then non-governmental organizations like Restorative Justice for Africa initiative. And then finally, he gave us a history of legal framework of restorative justice in Nigeria, starting from the Constitution, then the policy document, the ACJL in Lagos in 2011, as well as the ACJA, then the Nigerian Correctional Services Act of 2019, that now specifically mentioned restorative justice under the non-custodial measures of criminal justice administration. That was a wonderful presentation, Mr. Gift, and over here, we really appreciate the work and the industry that you put in bringing out this presentation. Okay, we are towards the last lap of this webinar. So this is the time for questions. So if you are still here with us, just type hi once again on the chat box. You are still here, you can hear us, just type hi. You are still with us, you can hear us, type hi on the chat box. Let us keep it coming. Type hi, you are still with us. You are still with us, just type hi, I'm here. Hi, okay, that's coming in. That's coming in. Thank you very much. So we need to take questions from 2 or 3 persons. So just type your question on the chat box and we'll read that out, or you can direct message me. So what questions do we have? If you have any question? Do you have any question? Do you have any question? Do you have any question? Any question? Any question?
There's a question already in the chat box.
Okay, let me see. Okay, let's see the question. Okay. Okay, someone asked a question, Annabelle. She said, what if the offender is not remorseful? What happens in that situation? Or how do you truly know that an offender is remorseful in order to perform restorative justice? So Annabelle is asking, yes, we've seen some cases like that. What if the offender, the offender is not remorseful? Or how do you know that an offender is remorseful before you can perform restorative justice? Okay, our first speaker, maybe you can use 1 minute to talk on that. Then Mr. Gift use 1 minute to also give his thoughts on that. Thank you very much.
Thank you, Chibueze. Okay, of course, that's a concern, but I think one of the issues something you mentioned is quite pertinent in this regard. A lot of times in restorative justice, it's not just about talking. There are also agreements that sometimes parties have to enter into. You mentioned the case of somebody who has taken, money or property, and there must be a way for restitution to occur so that the victim is giving something back because he has been put out of pocket because of the stealing or whatever the situation may be. In those cases, you will know very quickly whether the offender is remorseful or not. Is he able to keep up to his commitments? That's enough to tell you whether the guy is remorseful or not. Of course, you may have some people that are brilliant actors before the facilitators, but most time human actions will fail themselves if the person is not truly remorseful. So I think the process of getting to some sort of settlement or some sort of agreement will let you know one way or the other whether the offender is really interested in restorative justice approach or not.
Thank you very much, Emergence, for that wonderful presentation. I think there's a second question here that Mr. Gate, for the sake of time, will handle. But on the issue of whether the offender is remorseful or not, one thing we have to understand is that restorative justice process is a voluntary process. It's not mandatory. So the parties, that's why the victim, the offender, and the facilitator are brought together. If the parties don't agree, let's say the victim says, no, I'm so angry, I want this guy to go to prison, you can't have restorative justice. If the offender, on the other hand, is not remorseful, has not seen anything wrong in what they did, you still can't have restorative justice. So it's a situation where both the offender is remorseful, then the victim is willing to accept the apologies or the restitution that the offender is willing to bring to the table. I think we had a case like that. The first time we sat, or the first time we met, the guy said he did not collect any money. That no, he didn't collect any money. That so many stories we are told. The second time we spoke over the phone for a while, so we took 1 month space. Okay, by the time we met for the second time, I said, okay, he collected, but it's just 100,000 naira he collected, not 400,000 naira he was being accused of. Okay, then he now said he was sorry for the one he collected, and he had issues in school. So the victim was like, okay, you pay 200,000 naira out of the 400 that I realized I was missing, and we'll settle this matter. So they had an agreement, and the person has started paying. Okay, so that's it. So at the moment when the offender was not remorseful, nothing was done. They met and would have gone to court. So there must be the offender must be remorseful, the victim must be willing before ROJ can take its place. Then the question now we have, so Mr. Gift, this question is for you, and it's a very heavy one. The person is asking, I want to know if ROJ can be used for some sensitive crimes like murder or rape, and how can it be done? The person wants to know, that's Angela. She said she wants to know if it can be used for some sensitive crimes like murder, rape, armed robbery, and how that can be done. Over to you, Mr. Gibbs.
All right. Okay. So I think this is a very interesting section. Listening to people make their inputs, then the speaker too. One key thing I just want to state here clearly, maybe I will just add to what Chibueze said. Restorative justice is voluntary, not mandatory. What, from experience and from what we've seen, we're beginning to put a but to that comment. It is kind of mandatory, but there's no legal backing. And I will explain why I said that. So I do with data, so I can explain to you. From 2000 and let me just make sure I give you the right figure so I don't quote out of context. So from 2010, the total number of lockup in Nigeria was 45,000. Out of that 45,000, about 11,000 are recidivists. Recidivists are reoccurring offenders. That is a whole chunk. That's a very large percentage. I don't know if you get. Now, some of them that we interviewed, that was in 2017, said they came back to crime because by the time they were released or their case were settled, the society or their immediate community didn't welcome them back. They were discriminated and they resolved to crime. So some of them, they are coming back for the 6th, 5th time for serious offenses. All right. So, and you know, the Correctional Service Act of 2019, the Part B of it enables the Correctional Service Act now to have a unit, a non-custodial unit. And some people in that non-custodial unit are supposed to be trained to let people understand, the victim and the offender, the importance of non-custodial measures, including restorative justice. All right? Because that would help drive this number of recidivists down within the custodial center. That's one. Two, into the question, can you use it? Importantly, yes, you can. But people should not misunderstand the usage of restorative justice. Now, somebody who has committed a criminal offense such as murder or rape, there are stipulated judgments for that. But then, why you use restorative justice in that trial or in that process is so that by the time the person has served this term or do whatever the law has asked him or her to do, he will easily reintegrate back. So it does not mean that, oh, because the offender say, oh, I forgive. There's a classical case I know I handled. The woman lost the husband, I think, arguments, and the young man overpowered the husband and, killed the man. Now, the issue is this. The man has a son who is going around telling people that if he like the man, like, let him spend 100 years. Any day he comes out, he will kill him because he killed his father. Now, that is a very serious issue. Imagine that young man going all the way to wait until that man comes out, kills him, then he becomes a murderer himself, then goes in. I don't understand. That circle of violence will keep repeating itself. So to avert that, restorative justice is very important. And it's important to know in practicalizing restorative justice, the first sessions, which I know in subsequent training, Regia will bring, the participants will be able to experience the practicum sessions for non-custodial measures, which include restorative justice and all that. The first sessions are the most difficult sessions, especially when it has led to loss of life, loss of properties, and very key issues like rape. The first sessions, I can tell you, I myself, I try to dread it because it's the most difficult session. Bringing the victim to look at the face of the offender and you want to make a result is always difficult. But past that first session, the next subsequent session, you see, you're not saying the law shouldn't take its course or the court shouldn't do its work. All you're trying to do is that for futuristic and posterity purposes, that such person would easily reintegrate and therefore helping reduce recidivism in the society. All right. So you apply it in that approach, but that does not mean that those who have undergone restorative justice in criminal offense, therefore they are free to go. No, that's not it. Thank you very much.
Thank you very much, Mr. Gift. That's a wonderful one. So I think Mr. Gift pointed out we should not misunderstand ROJ. ROJ is not, I think Stephanie will always say, it's not a getaway free, the way she used to catch it from consequences of your actions. Okay?
It's not a get out of jail free card.
Get out of jail free card, and that's the word. So the fact you say restorative justice does not mean that somebody commits a heinous crime and now wants to pretend that he's sorry. And no, if you commit murder or rape, whether you are sorry or not, Mr. Gift has pointed out there are certain mandatory sentences that the judge must hand out to the person. Okay, there are mandatory sentences that must be there. The judge does not even have discretion there, whether you are apologizing or not. However, what Mr. Gift also pointed out is that it can help to bring closure to the victim. He gave an example of that boy that was angry about what somebody did to the father. So restorative justice could ensure that boy is no longer angry, that boy will not commit a crime, and that boy will find closure. And there are a lot of cases like that. During one of our trainings, there was a family that the friend of their son killed the son, and they were very angry. In fact, they were so angry that what they now gave the person was 5 years or 4 years imprisonment. And they asked themselves, is this what our son's life is worth? 4 years in prison, a young guy. But by the time ROJ came into place, they were able to sit down with the offender, talk with the offender, of course, after they passed through the first stage that Mr. Gift dreaded. The first stage, of course, must not necessarily be parties sitting down. There could be letters being written. I think Mr. Mokinovo mentioned that letters can be written. When the parties are okay, then they can sit down. By the time they sat down and even looked at the person that killed their son, they realized why the person did what the person did. Not that it was excuse, but they could understand the circumstances. And I think they even took up taking care of that person when the person came out from prison. So those are some of the things that restorative justice can actually help us do. So can it be used for sensitive crimes? Yes, it can be used for sensitive crimes, but it does not mean that if the person is supposed to spend lifetime in prison or whatever, it won't be there. Although when probation is being considered, of course, issues of probation, some of the non-custodial measures that are provided from the Nigerian Correctional Services Act are considered. Some of these things could also help to mitigate the prison term and could also provide other ways that the person can be reintegrated into the society. Okay, thank you all very much for this.